So Chairman Wontumi on any new lawyer Samuel Atachia omo delay tactics and as a strategy omo pese omo di wura case no mo yaba aba be breaki ho ensem bebre e de amam na ndra da ate ba ko a esre Chairman Wontumi ne lawyer officially file a motion to a court and they say omo schedule a Chairman Wontumi the 3rd July judgment no abusua and yeah, that's sorry, yeah. Attorney General, Eddie and Sib Ababutuga, while posing a application now, or say judge, and schedule and as on reschedule the 3rd July judgment. Attorney General said that what 29 ATM. Now, Uhuni say, Samuel Atachia, chairman won't to the lawyer, a quite be no more person of us no delay case in Abusiano. And ya protect at the actual ye screen no and chain at the amam. Or say summoner boy mining case. Attorney General opposes Wontumi bid to defer July 10th judgment. Accuses Atachia of bad faith and deliberate delay tactics. HSA Attorney General no crampono was also at the pim a year Samuel Atachia, chairman Wontumi, the lawyer, and also on the 3rd July. Chairman Wontumi Kianeke bibi besi e won side into the oil no ohun ni say eye ne intentional eye deliberate washeda and na opese or the delay case no Kevin Taylor so aba e de ho nsem bebre aba betudwa abusua Chairman Wontumi Ghana has say opo obi a waye hye pa Chairman Wontumi e che say work happen na ekoso kra joy a Ghana for watch no Chairman Wontumi enye ho e na adwen eda mom yanko na Yankonkotie and some Kevin Taylor so Edibetu Ghana answer and Ebekon Ghana has said open computer papa and a laptop papa where you use a Buria Perosi computers and accessories. Abusuani location and Yairaquine or Wokumasi Wokrum Estate Eli friend number ya a GUI screen ya 0247 030108 and answer 0597 942133 Perosi computers and a laptop papa if you Mummy Buria and some near bar Yadiaka at Wamuso.
Wontumi's lawyer, Samuel Achim Police Atachia, has urged the High Court to defer judgment beyond 3rd July 2026, citing the registry's failure to furnish him with the record of proceedings needed to file his written submissions by the court-ordered deadline of 23rd June 2026. So I'm for South Central so Bantama Kwabre. Eye moa mo bekwai. Me sai bekan brofro na metim e wa santikasem. Twi kasem na ye nyina ya tiase. Wontumi's lawyer Samuel Achim Police Atachia has urged the High Court to defer judgment beyond 3rd July 2026, citing the registry's failure to furnish him with the records of proceedings needed to file his written submission by the court-ordered deadline of 23rd of June 2026. Eye Atachia a obianim se ose Achim Police and Atachia oye chairman Wontumi a ojina court because of Samuel boy a koye galamse wo say nsu and nsu form. Atachia say and the wako court waka kire court say eye 3rd of July ya ebe ya chairman Wontumi na asem no judgment beba no o say wako kire court say in fact eye court ejumafo a ye from eye den eye you're from registry for an omomoko from the registers or whatever they call them no. Or send some of the information be mano. Na sa information no ni nyina ne time a chairman want to be started call court. And some akoso court nyina na nko say sa ansem ni nyina ya de mano na oko kenkan. Ansa na watchro ono ano the written submission. Into because a court registry for no entumi amfasa document na maninti or catch court ne say 3rd of July judgment no mama judge ne nye onto nhyeda makache some people for mo Jimmy Atachia say, before betuma try written statement, remember, time Chairman Wontumi a change appear could be okofa Atachia by no, judge ni can be or court. Time ye change appear could be, maybe kind remo, Murefi. Yakofa Achim police, Atachia, say ombe Chairman Wontumi lawyer no. Me kind sa judgment ni chira the judge ni kan ye. And judge no actual our judgment is not or you're very specific about the timelines. Judge no judgment no can say Chairman Wontumi ni lawyer nya problem. Na so be change e dey attaching ba only problem. Now attaching still from that time no to the 3rd of July no order who obey 2 weeks obetumi dey actual written submission. Into on there the 3rd July judgment no the beba still from there near year attaching no order who omre and the attaching say registry for na document no document attaching pa attaching say from the day na Chairman Wontumi start court was some rabo case wo no enkrata ne nsem maka nyina no court mfama no na onya abotrenkin kan ni nyina attaching ya kwasea attaching say mema judge no on the 3rd mema ne for judgment ma ontun sheda adentra from the day na Chairman Wontumi start court no sa from that day no ensem court omo chiregu krata so nyina no awo se court ni nyina ma no na onya abotretena se na okenkan wie na nakoma todie ma na wono achro no written submission na ochro submission wi ansa na judge no aya na adwene se obe pronounce anase obeba bontena be ka se judgment ni nie nti right now attachia say yenjai bibia mema judge ni cho judgment onjai nkotena baby na ono attachia enye de all ye wie sa na attachia ka kire Ghana court kwasiafo na mametwe adwene ko bibi so bebe kan sa judgment na kire day na ye change apiakubi attachia eco court apiakubi ene Chairman Wontumi court eko ka kire judge ni say Chairman Wontumi so asesa apiakubi no judge no that day no o ma ruling bi moma yanko ne sanko kan ruling no ehona be unsa attachia omo nyina nim say Chairman Wontumi ejimi ene omo dada no mokai sa ruling way I read it on the show mokai sa judgment way this was a judgment I'm reading wa day na eye Chairman Wontumi ka say wapamo apiakubi no meka chem say plan na Chairman Wontumi mo afa MPP for nyina say ompese om delay case no omo pese judge no be read judgment no anytime akofa attaching aba na attaching be ma excuse na 3rd July no 3rd June no judge didn't me for judgment ni mba say na be ya munim say the following week no court be call a break na omo tumenya 3 months na omo dey call election no mo Chairman Wontumi na omo be ka kire wi ase say omo national chairman na NDC anase aban akina tum omo plan na ani enende ohun plan na abemu no omo jimi mo ka judgment we eye in the Superior Court of Judicature, in the High Court of Justice, Criminal Court 4, held in Accra on Monday, the 15th day of June, 2026, before Her Ladyship, Audrey Kokuvi Tay, Justice of the High Court. Now, sir, a judgment way. Me reading in United and church, which I will say, judge in the judgment of my no, sir, judgment clearly shows say, judge, written submission in your DBA. A bit may affect the judgment. Written submission. A very vital and a vital. Without written submission, you bet me the judgment abana. Yes. A judge a ruling or can wom. Now ruling in ye. Before the court is a motion on notice. Before the court is a motion on notice for leave to withdraw legal services for 1st and 3rd accused persons. Prosecution has raised preliminary legal objection to the application. I have also listened to learned counsel on both sides on objection raised. I have also considered the applicable law. It is the considered opinion of this court that the instant application is a supplicage in the sense that there is no procedural requirement. There is no procedural requirement for a lawyer in a criminal matter to file an appearance in much the same way, there is no such procedural requirement either under the criminal and other and other and other offenses. Act 1960 or Act 1960, Act 30, or by judicial precedent that I have come across, that a lawyer who has decided to cease to act for his client in a criminal matter must seek the leave of the court to so withdraw. Or say, aseme dene nimu no, and we're ruling no, aseme dene nimu a omu pense mu a ende eye apia kubi aba court ebe ka che ono judge say one the client seb your client no high no behind the scenes privately apia kubi be ka che say ono chema wontumi nya adwuma bi no say court mramu no any court a watena aye adwuma no say lawyer odi obi high no de na ba court say sa nipa no lawyer no ne sa nipa ne gya adwuma di a ene de enfa court wo say sa lawyer ne ba court wo be ka kire court say chairman wontumi ne high me ne kan sika magye e wo kukuom ende oso ne nya adwuma judge ne say onhu wo baby ada say obi high privately na say nipa no pese oba ne lawyer bi ma e wo say wo ba me court ana wo ba Ghana court be ka kire court say ai me be ka kire mo chairman wontumi ne nya adwuma bi o say emra bi eni ho emra bi ani Ghana kire say wo de chairman wontumi wo apia kubi wo de chairman wontumi nya adwuma bi ma e wo say wo ba court be ka kire say wo de nya adwuma bi because chairman wontumi high wo no na judge ni ho na attorney general ni ho na court of Ghana na eni ho bi. That is a private matter. You are not even supposed to come to court and tell the court to say me ne chairman wontumi nya adwuma bi. No, contract na mo sign ya baby a mo sign contract mo nkona mo nkotwam. Inti judge ni say eye ne wanwa say wo apia kubia say be wo ye lawyer pagini a wuni mu mra no ende wa begina court ka kire ne say me ne chairman wontumi nya adwuma biom na emom no chairman wontumi akofa lawyer foforo judge ni ruling ni asem o kan ye ni natie de aka o de kan ho. Or say even though the respondent has raised other grounds of objection, the objection is sustainable on only one main ground, which is the application by counsel for leave to withdraw from criminal proceedings is not a function of any rule of procedure nor of settled case law jurisprudence. Or see, a woman say Attorney General Krano a raise issue say the air question no sebio emfa kwemu no say apart from Attorney General sebio or raise the issue about the air question court no ono angasa krampo no woni say court mremu no sa de na nya adwuma nyansa bi anim say wo a wo ye lawyer wo ne wo client mo papa mu no e wo sa wo ba court be ka say me client papa mu na wo client no all high wo no na court wo hobi na judge ni kore ni mo chro bibi mo me anko kan no ene very very important. Or say the instant application is alien and not a procedural requirement in criminal proceedings. Or say asema apia kubi bejina ne nim kaye so ono aba court ebe ka kire court or say sebio enimrem court krampo nim saade no emfa so bia nyansa bia nim eye alien court kran recognize saade no. And okore nim no say counsel herein does not need or say counsel herein or say appear could be time and or say on the chairman wontumi nya adwuma bi no say counsel herein does not need leave of this court to withdraw as counsel. Or say appear could be sebio eni krampo say o ye na adwene say oba court abeka kire court say or the chairman wontumi nya adwuma. Or say nyanse bi anim. Or say counsel, which is apia kubi ade oye no faso bi eni so ensisa bibia. In fact apia kubi experience or one who say saade we kura wa ye na eyenim guasiema no because court does not recognize contract between a client and the counsel or his lawyer. No. Now judge ni kaso no course or say this is an issue between himself and his client. If he chooses by his personal decision to abandon his client at this stage, that will not affect the timeline of the proceedings. I say, so on one etu no bo aka se on chairman wontumi nye adwuma bi ma judge ne say saa de ne eye apia kubi ni chairman wontumi omo ankasa na afa omo ho adwene so omo be saa na emom ro be se omo nyina te ase se wantwi anase disagreement ato apia kubi ni chairman wontumi se ontumi nya ne lawyer biemu no o say court way dwuma de aye di no enka ne court enka ne tie court ne de eye ne de eye or say timelines. That means time or ka say or the judgment ne beba on the 3rd of June no and sesan appear could be the lawyer appear could be the client nyan to kwa say or sesan lawyer na or say court date ayahye no say ye de the judgment beba no sa entokwa ne nsem no enka court timelines ho be a court gina na court gina where any ruling they can't be see end asam no so. Now, Judge Nicole no can send me, and I want to let me see this. Number 2, right? Okay. Judge Nicole no can send me. Mama me read it. Emenya butana bijujum. Or say the application is not competent before the court, assuming without admitting that the application were even competent before this court, the court has taken notice that the lawyer seeking to withdraw has not directed service on his own clients to enable them appropriately respond. Or see, say, opeso oje apia kubi ade no kura tum na okasa okay, de wa ye ne ya. Or say apia kubi na nkasa nkwampo no, ontumi en serve chairman wontumi formally. Say ontumi ne chairman wontumi nye adwuma. Apia kubi ba court no, wan fa krata bia mpo amba court amaka court. Say court, me client way, this is a formal document that say mene the contract no and there is easy or say wo apia kubi a wo se woni chema wontumi nyedwuma wan fa krata bi mpo amba kire say woni chema wontumi no woni ne nyedwuma bi so there kra da kire say there wo be kana enya atro because say woni nipa no official eye contract na say wo ba court krampo a enim rema be ka kire say woni ne nyedwuma ya at least weaponize yourself a little bit with some document to prove to court to say even though nyansa bia nim se maba be ka chem so bi ne gya adwuma na krata we kura mpo tumi di adanse wa mfa bibia mba o de won sato wa adwini to e na wo to fin abagina ha se wo ne o client nye adwuma judge say asem no ensisi so sabio a waste of court time. Now judge no ruling American chiro no consequently judge no say, in fact, let me see something. All right, mame ensure we because I am marking red no. Now this is the part I want you to pay attention to. I am marking red no. That is from the consequently. And the last number no. Judge no call the judgment no tro bi or see. Or can be or see. Consequently, since filing of closing addresses is optional right now, attaching say sa closing addresses no. Enunti na court no entry judgment ni nkwechiri na judge na last ruling no can be or say consequently since filing of closing addresses is optional and not a function of the rules, that is to say there is no provision under the rules compelling a lawyer for an accused or prosecution to file address. See brofuni Judge the ruling now here in the last time or money clear or say consequently since filing of closing addresses is optional and not a function of the rules or see written addresses no Sebiana judge focus o yedi asem na wie me ba be kire ma adwene me opinion ni in a form of written statement or see optional or say mrabie ni wa kire se saade no say yanya ye ntumi mu asem no or say optional opinion of the lawyer enti optional no enya dia say yanya ntumi ma judgment ne mba so judge ne last ruling no kan in the send attaching say let's say the all can on the credit nensan to me anka their proceedings no and now whatever happened in court now sa de nensa kan cry whatever he will write wouldn't affect the outcome of the case, because they are just opinions of the lawyer. They are just lawyers' views on the matter. It does not change the evidence the judge is basing on to write his or her judgment. This is simple. You don't have to complicate this. Atachiamu Jimmy Jema Wontumi. Omo dada MPP for no Jimmy for. Now judge ne can say me or say there is no provision under the rules compelling a lawyer for an accused or prosecution to file an address. Or say can be or say addresses are optional statements made by lawyers to articulate on the merits or demerits on the case one way or the other. Or see, sir, addresses na attaching say, yam stati encofa documents in number and or see, those addresses are optional statements made by lawyers to articulate. It is the views of the lawyers, how they see the case. It does not affect the evidence the judge is basing his judgment on. They are just views. They are just opinions. And the judge was saying, those things are, yeah, they are on Embrabian words. I say, say, written submissions are, the judgment cannot be brought out. No, or say, optional. You can decide to do it, you can choose not to do it. And we have seen cases where lawyers have come out to say, I have no written submission. I'm done with the case, let the court decide. So whether you write or you don't write, the judge will not even read your submission. 99% of the time, the judges don't read the written submission of the lawyers because the judges don't want the opinions of the lawyers to affect their judgment, which is based on evidence before them. And to say, me a judge, now say, me try my judgment. I will not waste my time to read an opinion of a lawyer. I will not waste my time to read an article a lawyer has written about the case because I have to base my judgment on the evidence that was provided during the proceedings to make sure I have the right things. The opinion of the lawyer does not matter here because it's not because of the lawyer that I'm sitting here. I am seated here as a judge because of the evidence put before me for me to make the judgment based on the evidence. So the court or the lawyer's opinion does not matter. It does not affect the final outcome of the case. It is attached here, say, because of a written statement, delay documents in San Keniti, judge and post for the case, attached here is mad with Jimmy. Or that MPP4 because when you say MPP4 Jimmy. Now the last part of the judge in the ruling, and then they're very important. I'll say the court would by this extend the time of filing written addresses from the 17th to the 24th. In this all calculate here, judge in the cross touch and say you have time. Because nanka also or making sure say obi any obey written submissions on the 17th and a final day. But what the judge did was that even though the written submission is not necessary, it's your opinion. If I don't allow you, because you have decided to write it, if I don't allow you, somebody will say, I am trampling on your right. If you want to waste your time and write the written statement, you have till the 24th. Judge need to be 1 week is I can home. Adia chinya attach about court to say I yen delay judgment because here document from now agro na nyawa agro abrofu no budi o magro enom se bedi bi wo ba ya wo so be tro rules abofu. The written submission is not even a must. Yeah, ma o chance say chiro bi na kire ai sika kakra betu magine wo to show working. Sa written submission na they write, it is proof to their client to say, I am working. Send a opportunity chairman want to be sick. Oh, person over money by Emra. Judge say, Enyamra. Just to prove to your client to say, oh, yeah, Juma. Just to prove to your client to say, I case the course, say, I'm Mr. Medjunifa. It is that the judge in Po is being considerate and saying, you can choose not to write it. And if you can choose to write it, it does not affect. Not say, oh, and they will now determine, say, an optional thing, open say a better fact, and I say a master. Now, but you don't know the law. You don't know the law. You are a liar. You are lying to your client. Attach it is anoma or that Jimmy. He needs to know they are lying to him. Now, the Attorney General, it is attaching say or pleading with the court to say or non ensanka documents. Now, court no and postponing the judgment from the 3rd of June. No. The Attorney General has written something. The Attorney General has reacted to oral. I reacted to attaching statement. And then no matter. Case updates. Operation Recover All Loot. Oral for the statement about Wontumi. And this is the statement from Oral. Republic versus Bernard Siakon, aka Wontumi, and 2 others. The Attorney General will strongly oppose the application for deferment of judgment brought by Mr. Samuel Atachia, new lawyer for Bernard Siakon. In a 13-paragraph affidavit, so the Attorney General has responded, has reacted. In fact, the Attorney General has submitted a statement to court to say they oppose the statement from Atachia. They insist, they are pleading with the court that court initiated the 3rd of June and the court needs to follow its emra. So the Attorney General has reacted to Atachia's statement. He said, no, they are opposing this. They believe, he said, the court has set it 3rd of June as the day for the judgment to be basically pronounced. That the Attorney General is saying the court should stick to the 3rd of June. 3rd of July, sorry. 3rd of July. I'm sorry. 3rd of July. Now, Uri I'll say the Attorney General will strongly oppose the application for deferment of judgment brought by Mr. Samuel Atachia, new lawyer for Bernard Siakon. In a 13-paragraph affidavit, in opposition deposed, to by Nana Ama Prempe, a senior state attorney, and filed this afternoon, the Attorney General strongly argues that the accused persons having been represented by counsel throughout the trial, and that counsel only withdrawing voluntarily and not for cause, the proper source for a new lawyer to procure the records of and any brief or briefing on the case is the outgoing counsel and not the court registry. Now, it is further deposed to that the decision by counsel to abandon the proper source of obtaining the records or brief of the case and to rather apply to the court registry is actuated by malafide. What is this? Malafide. What the heck is this? Malafide or malafide, and a desire to frustrate the court of justice. Finally, the deponent urges the court to exercise its discretion to summarily refuse the present application as a grant, therefore, will constitute the court's endorsement of abuse of its processes and public ridicule of the justice system. Hearing of the application is slated for Monday, June 29th, 2026 at 9 o'clock in the forenoon. Now, basically, what the Attorney General is saying, and they say, court ne man ho kwan na court ne eje nkwasi asema atachia kana ebema ewiase nyina ngu se court ne krampo no enye ready to take a decisive decision, because Attorney General asema okanyina ne say atachia time obeji case no sebio court man time say onko tro ne written submission no, it was upon Atachia to make sure say sa document in nsaka whether to go to the registry himself or to approach the former lawyer, which is Apia Kubi, to do what? To give him all the documents. You know, it is not the court's it is not the court's responsibility to be feeding Atachia daily with documents. It was upon Atachia if he really wanted to do this, because in the first place, the court had extended the written submission time for Atachia. So it is onto Atachia or up to him to make sure. So if he's really ready to write his submissioner, he was supposed to contact the court. He was supposed to make the move. The registrars, they are there. If you approach them, if you force for the documents, you will get it. In fact, the former lawyer also has the proceedings. He could have even approached the former lawyer, which is Apia Kubi, and taken a document to basically write his submission. But if he failed, And I say he's decided not to do it. Na and the opposite of blebu court no, opposite dada court no, opposite of force court no, some decision bia. Later in conformity court no, abo court no, edi court no who fell there. The Attorney General is saying that the court should not allow this to happen because Attorney General no opinion in and say the attaching no deliberate. Waboni trimu pose obeda da court no ama Ghana for astati atwetwe court no se court no entumi ndi ne mra so entumi ndi ne time so na court no krampo no entumi endi no ho so enye de epese ye. Into Attorney General they will say the court should go ahead and on the 3rd of July no come out with a judgment because attachia so person obo ne client to partner so person man 14 opinion they are all true about case now. He needs to make the move. He needs to find a way to get a statement or document or proceedings, you know, and then write his submission. But if he has failed or he fails to do that, then it is not the responsibility of the court to be pampering Atachia, to be begging Atachia, to be calling Atachia to come for the document. No, the court at the end of the day, I say on the 3rd of July, and before and then Judge Nedinkanka, written submissions are optional. Written submissions, it does not affect the final judgment. Written submissions are opinions of lawyers. So whether he writes or does not write, the judge should stick to the first ruling by telling us to say, written submission cannot affect the final data or the judgment. Remember? So the Attorney General is saying, they oppose it. The judge should do what? Should go ahead, bring out the judgment on the 3rd of July. On Monday, and I'm about 29th, on Meshia court. Now, as same way, Omakutie the judge Becca. But to me, I believe the judge should not listen to any of these nonsense. The judge should not even come to court. The judge should come to court on the 3rd of July. No more reading the judgment. It's a waste of time. The judge should not even come to court on the 29th. What is she coming to do in court? The judge, they are not obey court. Into our court, okay, attaching my own ruling. I'm ruling, I am going against it. Is the judge going to come to court and go against her own ruling? No. If the judge comes to court and goes against her own ruling, then the judge is not fit to be on this case. Because you made an emphatic ruling. You made Ghana for understand. Say, your ruling is clear. Written submissions are optional. It does not affect the final determination. You are basing on the evidence that was put before you by both counsels, the prosecution and also the accused. That is what you are basing on to write your final judgment. Submission, whether written or oral, it does not affect the final outcome. So if the judge comes back and says, okay, Atachia, you are making sense, then it means the judge herself is not supposed to be on this case because you cannot come back and fight your own ruling. Your own ruling should guide you to go ahead and finish the judgment. You, the same judge, cannot come back and say, I made this ruling, I am going against the ruling. Then the judge will not be fit to write the final judgment. It will show that the judge is not consistent, the judge cannot make decisive decision, the judge does not understand the acts that protects the court. So to me, respectfully, I will tell the judge not to even come to court on Monday. It's a distraction. The judge should appear in court on the 3rd of July and read her judgment. So if the lawyers of Chairman Wontumi from Apia Kubi to Atachia, if they really want to help Chairman Wontumi, by now, nanka also omo written statement abba. So to me, I have strong support for what the Attorney General has said. The Attorney General is saying, whether submissions are written or not written, it does not affect the final judgment. Atachia wants to waste the court's time. Atachia is playing politics. Atachia himself, Jimmy. My advice to the honorable judge is not to even come to court on Monday. Take your time and write the judgment. Memenya judge. Ghana for be judges. When I would send from day one to the last date, you are the one who can give us a ruling. The chairman won't win the bonnet. Now say he's going to walk out. Nobody will have a problem with it. Say chairman won't be so the bonnet. Now Embrano or na obey atia. Say Embra when ujina so edia judge chairman won't me. We will all accept it. That is why the law is the law. That is why the law is the law. And the good thing about this whole thing is 3rd of July is a holiday. A lot of people will come to court. They will all come and witness what will happen in court. And the good thing about this whole thing is the 3rd of July is a holiday. And if the 3rd of July is a holiday, we will all have time. I will come here. I will come and explain the ruling to Ghana for every single sentence. Intimacy eye Chairman Wontumi. Catch attach and say, you see Chairman Wontumi make no crunch. MPP for him so with Jimmy. Chairman Wontumi dey na adwene wo form. Chairman Wontumi. MPP for him so with Jimmy. And all these MPP lawyers, they are telling themselves each other behind the scenes, so with Jimmy, they are taking your money. They know. They know you are not smart. They know you cannot read between the lines. They know you are not intelligent enough to know how the case is going to end. They know, say, we are dumb. You are not educated enough to sit and analyze the whole thing. They are playing with you. They are playing a nice game with you. Eh? Most of them don't want you to even be leading the NPP. 90% of NPP, they don't want you to be the face of NPP. And from the day who say abide the court because of Galamsey, 90% of NPP they were happy and they are still happy because say you played about 80% role in the defeat. Say so many Ghanaians voted against the NPP because of your actions. So MPP that is why Chairman Wontumi Kokota, you don't see more than 20 MPP people there say we came to support. You never see it. You know why? Because most of them want Chairman Wontumi to go to jail. Mahmoud Bawumia, why is just Chairman Wontumi? He knows Chairman Wontumi is done. Chairman Wontumi is a daft guy who, for some reason, Galam said to Obenye Skakakra, it's not the team of Nyansa, almost play now till now. And international Chairman Wontumi court. Chairman Wontumi person national chairman, you don't see anybody following. You know why? Because they all want him to be in jail. They wish Chairman Wontumi was never part of this party again. Because the more Chairman Wontumi is around the party, the Galamsey title, the party will still carry it. So Chairman Wontumi Nyansa, you should have understood from day one that majority of the people in the party, party for penny for all of them don't want you to be back in the party. Yeah. Because they feel say one person protect you for yata also omode woma eye aban also omode woma emrano. So they believe say omode for yata beba de ankom de wo beji. Enti yesi bold siako de ni tiji akyerema no the real reason enie. Say bia na first won ti ase. Say omode oforiata beba ebema court ebua no ateto na no asem am yehu boni a wedi ne de ankom de bold siako na ebema mrano. What they are doing now is both siako no pe. Both siako and do on one casanity ebeja chirama. They will sacrifice both siako and protect Kenoforiata. And the NPP minority to the last person, they will protect Oforiata than to protect you. Because they see, say, if they give you to the law, now both siako udu tikwa jachirama omoge se Ghana for rebefi Oforiata. No, we will not forget. The law is the law. The law is the law. It boss yako bon paye catch them no kind of crunch row omo dadao. Yakase boss yako de tiji achirema, boss yako de tiji aso. Wo entwi boss yako wuti wo de beji achirema. So wan hwe ni ye a omo dadao. It is a bena yani asantefo ebu no opese ohun ni meaning na ene da ho no. Omo de boss yako ti beji achirema. Yedi eye oforiata beba Emma Sebio this year, Edin Tiabeja Chiremade, Yadi Bosiakwa Onimade, Bosiakwa or Sensasi, Bosiakwa Sebio, Odinquasi Asemanipa Empe Partino, Bosiakwa or Ma to me free and say, Yadi only Tibeja Chirema. It's Bosiakwa no pe. Tamana wu sika every wopa. Udi go de good table so okay can some nim oh yeah illegal mining who runs as now one I would wuti eja chirema Bosiakwa. Boss yaku Wontumi. Why na wudi utia kwa jachirema? Say wudi utia jachirema ma MPP. Now problem we hefa. Problem no day. Don't call Jesus. Wudi utia kwa jachirema ntine nde etufo. Memo mundada. They are lying to you. Don't ever let them lie to you. Omo dada. Party nankasa mpeo. They wish you were no more. They wish you never came close to the party again. Bawo miano kuranya ende kauche ma Wontumi omben party uni around the BM. He gets worried every time your name comes up. Inti achirema no o destiny no.
Now abusuya we ne ensema ekoso or political highway. So credit goes to 1957. The whole and a peke a flyer and it fits a free any assembly to according to chairman won't mean a lawyer and as he said attorney general has strike hard on him. You better master some of in some way at the